Blessings, beloved. Jesus is the way and the truth and the life, and no man cometh unto the Father but through him. In this video, I want to make it short and to the point. The High Court Judicial Review, it's called, between Stephen Tallon and the Director of Public Prosecutions and Ireland and the Attorney General. Well, at the outset of this case, it is said that the first thing that will be dealt with, this case concerns the constitutional interpretation and application of the Anti-Social Behaviour Order provisions of the Criminal Justice Act 2006 and the constitutional soundness of certain of those provisions. So they're checking, in short, the constitutionality of those provisions, those sections. The Act gives members of An Garda Síochána the power to issue a behaviour warning to a person who has behaved in an antisocial manner, as defined in the Act. The behaviour need not be criminal if the person does not comply with the warning. A senior member of the Gardaí may apply to the District Court for an order prohibiting the person from engaging in certain defined behaviour. Such an order may be granted on the civil standard of proof. A breach of the order constitutes a criminal offence. These judicial review proceedings arise out of the applicant's conviction on the 2nd of November 2020 pursuant to Section 117 of the 2006 Act for his breach on two separate occasions, August and October 2020, of a civil order which the District Court imposed on him on the 31st of August 2020, the civil order under Section 115 of the 2006 Act. On the same day, the applicant was also convicted of separate offences under Sections 7 and 8 of the Criminal Justice Public Order Act 1994, hereinafter the 1994 Act. The pertinent part of the civil order reads that the District Court hereby orders, pursuant to Section 115 of the said Act of 2006, that the respondent be prohibited from engaging in public speaking and recording anywhere within the environs of Wexford Town, including North Main Street, Bullring, Selscar Square, at any time. 5. The application seeks certiorari, that means to appeal to a higher court or a higher court's jurisdiction and knowledge. In respect of the 4 conviction orders made by the District Court Judge O'Shea on the 2nd of November 2020, as well as the civil order made on the 31st of August 2020, Judge Cheadle. Now, the High Court was most certainly called together to test the constitutionality of those sections. And I want to go straight to the conclusion from what was stated as being dealt with by that court. Again, and I want to reiterate before I go to the conclusion and start making points. This case concerns the constitutional interpretation and application. So what is meant by this? How does it apply? And how does its application and interpretation compare to what the Constitution requires of our of our laws? So how does it compare to, and how does it comply with, due process of law? The case concerns the constitutional interpretation and application of the Anti-Social Behaviour Order provisions of the Criminal Justice Act 2006, the 2006 Act, and the constitutional soundness of certain of those provisions. let's go straight to the conclusion. So that's fresh in our mind. They were to test the constitutionality of the sections 115 and 117. Also, the vagueness of section 7, I was told, would be dealt with, but I haven't seen that mentioned. Now, section 7 in the court schedule, I haven't seen it mentioned, which is equally as pressing an issue. So not only section 7, section 113, and as mentioned, section 115 and section 117. Okay. So straight to the conclusion. This is, in other words, the ruling of the judge of the High Court. By the way, halfway through this court case, I was told, the testing of the constitutionality of those sections was abandoned by the court. And I was not informed. Wasn't informed. This is a matter of public importance. It's a matter of public interest. Yet I wasn't informed. Have the public been informed of anything? Has anything been in the newspaper? Have the public been kept abreast of this case? Why were they made aware of it initially and not made aware of it on an ongoing basis? Why was I not made aware of what was happening? Why was I told the night before hearings that I would need to be there at specific time to do a conference style hearing of the case in motion a day before, and then not be able to access when I attempted to go online? The vagueness of section 7, I was told, would be discussed and tested. The sections 115 and 117, I was told, would most certainly be tested for their constitutional soundness. None of the above was done. Section 7 didn't make it into the schedule. Section 115 and Section 17 made it into the schedule. A judicial review wasn't thoroughly carried out, as it should have been, and therefore a judicial review wasn't carried out. The risk of, this is the conclusion of the judge, the risk, so only a risk, that's not, a risk is not something measurable, is it, by definition, as it pertains to law. So risk doesn't define inadequate definition. So I'll go through this with you. The risk of unwarranted means that the court didn't actually have authority that day. To be unwarranted means that you don't carry your authority through into your behaviour. The authority of your office into your behaviour for what you're doing is unwarranted. The risk of unwarranted interference, therefore your decisions on what arises out of that court cannot be upheld. The risk of unwarranted interference with personal rights, they be your rights as an Irish person, associated with the broad definition, and they're afforded to everyone, the broad definition, okay, so it is certainly mentioned that a broad definition was given, must have been given, if it can be restated. So the question is, where and what is the broad definition? Because, I mean, we can't allow for vagueness, or else you don't have anything concrete to go by or go with or work with. The risk of unwarranted interference with personal rights associated with the broad definition of antisocial behaviour. Well, what is this definition of antisocial behaviour? Antisocial. What is it? I haven't seen it. Nowhere in the DAR, I have the digital audio recording of the initial court case. Nowhere in the digital audio recording, or for short DAR, was it stated what the court deemed as antisocial behaviour. Yes, it's stated in an act somewhere, but this broad definition of antisocial behaviour seems to be something that's newly mentioned but undefined. So it's kind of in obscurity. It hasn't been clarified for the reader. Definition of antisocial behaviour, which occurred in this case, is compounded by the lower standards of evidence. So lower than what? Lower standards of evidence. Lower than what? Well, we can only reasonably say lower than what is lawfully accepted. What other measure do we have? We have what's lawfully accepted and what's not lawfully accepted. So then we can deduce or extrapolate that to say lower standards of evidence means that you are stating that they're lower than what is lawfully acceptable, unless you're establishing a new lawfully accepted standard, which can't be the case, because it would nullify every other time the standards of evidence are implemented. Because now, those standards of evidence which were required would no longer be required across the board. Otherwise, there's some sort of discriminatory action and some sort of manipulation being afforded by legislation in isolation from the rest of the law and every other court case that took place. But we can't have that. We can't have one judge having a different standard of evidence being required than another judge, because there would be an inconsistency and everybody wouldn't have the same rights before the law. Because this judge, if you got out of the bed the wrong way, so to speak, could have a lower standard of evidence required one day and a higher the next day if he liked you. And we can't have that, because we have to have a standard of evidence required that is the same across the board, so that everybody's held accountable to that same standard, so that everybody has the same rights afforded them and has the same incumbency and responsibility that goes along with having those rights. So just to continue, the risk of unwarranted interference with personal rights. So my point is, to mention that there's a lower standard of evidence means that it's lower than what is considered due process of law. So that's already been said. So what I want to do is I want to identify doublespeak and I want to remove it and highlight it. Due process of law requires a certain standard of evidence. Now, if you didn't know, a court cannot convict somebody on prima facie evidence alone. That means prima facie means evidence given at face value and is merely hearsay before a court of law. It is not solid, irrefutable evidence, and therefore you wouldn't say it's a lower standard of evidence. You'd call it prima facie evidence, which means that it's not actually proof. Prima facie evidence is not considered proof. And it does say here, standards of evidence and proof. So a standard of evidence being prima facie can be considered evidence simply because it's admitted to the court on that day. It's something said to the judge to set the scene, the recollections or whatever it is of one individual person, what they want to say to the judge about what occurred. But people can have differing opinions about what they saw. This is down to subjectivity. So because subjectivity is involved, you can't have a solid proof in somebody repeating what they saw. You need something irrefutable in order to convict somebody. So you say, I think it might have been John who took the car keys there, whatever. Right, that might give the guard something to go on, but it doesn't mean the guard could convict John of stealing the car. We give him something to go on. He might check where's John then. Might narrow his search. But then he might find No, it wasn't John. John was sitting down having a cup of tea with Anne. And then he's back to square one in his search. So it's hearsay, it's prima facie evidence, it's a subjective recollection or some summary of what occurred. And I mean, human beings forget things and add things, and Chinese whispers and all sorts of things, and people lie. And so you can't go on this alone, right? So the point is that you can't convict somebody on the basis of prima facie evidence alone. I'm getting back to basics here, just to show you how it should function and how unreasonable they've been and how sort of double speak they've been. And I want to expose it all before you. Now, solid irrefutable evidence is evidence that proves something to everybody in the room, whether they were there or not, etc. It's solid, irrefutable evidence that somebody can plainly see that is the case because of that evidence. John was seen on CCTV taking money out of that account with a card that wasn't his own. At this time, did it? Right, solid, irrefutable evidence. John, that was you. Yeah, and you must have used Mary's card because that's what it says in the transaction. Yeah, it was me, Judge. Solid, irrefutable evidence. Do you see the difference? Prima facie. Lower standard of evidence. It's not a lower standard of evidence. It's simply prima facie evidence. But you see, what they haven't done is been specific so we've anything to go on. They've remained vague, and by remaining vague, they haven't given us a start point. But you can't continue to remain vague. What you say says something. And because they've said lower than what is normally accepted, because they said lower standards of evidence, now they have to be called into question as to lower than what. Because they have stated something. So if the judge is saying lower standards of evidence, lower than what? Lower than what is normally required, lower than what is required by due process of law, that would be one and the same. So if it's lower than what's required by due process of law, it's an unacceptable standard that must be removed. Thereby, they have stated, by saying lower standards, that it is unconstitutional. Unavoidably, they have stated that, and we can deduce that. So they've already stated that section 115 and 117, if they afford the utilization of a lower standard of evidence, that it's lower than what is expected by due process of law. Simply using the term lower says that these are unconstitutional legislations. You can't avoid that. So then to say, oh, by the way, we've abandoned the testing of the constitutionality of these sections is disingenuous at best. Because they know that they can't avoid the testing of the sections. In order to come to a conclusion, they must have tested the sections and their constitutionality. But they said there's a risk of unwarranted interference with personal rights associated with the broad definition of antisocial behaviour, which occurred in this case, is compounded by the lower standards of evidence. So is compounded. So they've said there is a lower standard of evidence. That's not vague. So if there's a lower standard of evidence, that's a standard of evidence that's lower than what's required by due process of law. And if that is afforded by the legislation, they have already admitted that the legislation is unconstitutional. That's already stated. The court has already stated that the legislations are unconstitutional. But later on, they say it remains an open question to be determined in an appropriate case. I ask you, what case would be more appropriate? Especially when it was in their schedule to test the constitutionality of those sections. What are they waiting for? So they've stated this is an inappropriate case. Okay, so if it's an inappropriate case, why is it inappropriate? Why? You see the questions that arise and the things we can extrapolate, that are inferred, that are unavoidable corollaries of what has been concluded. It's an unavoidable corollary to say that if you think that there are lower standards of evidence, what are they lower than? And if they're lower than what's normal, then they're lower than what's required by due process of law. Therefore, if something affords that standard, which is separate from the due process of law, then it's unconstitutional because the Constitution is what sets the standards of law. They've already shown their hand, so they must um, declare that these sections are unconstitutional. They must. They've already stated they are. If they're saying that the lower standards of evidence come from those sections or are afforded by those sections. By the way, how can somebody who wasn't there, on the basis of what somebody's saying to them, end up in court prosecuting on the basis of what somebody has said alone? This is what they do. Adult behavior warning, headed paper. Adult behavior warning. What do? They basically take the verbal statement of a person, which is a complaint against another person. Then they go away and tell, you must desist from this behavior. What behavior? What Mary said you're doing. Why, you didn't witness it. It's what Mary said you're doing. But you've signed it, Gart. Why are you signing it? Are you saying that this is ratified information? Are you saying that what Mary said about me or her complaint in some way can, in and of itself, bring some kind of motion against me that's outside of the court, that hasn't gone through due process of law? You can now do things and act in a manner that is outside of the law on the basis of a complaint of a civilian against another civilian. When did you become some kind of referee between members of the public, favouring one side over the other? And then the first one isn't enough, but the third, fourth, or fifth might be, should we decide it is, and then 3 or 4 is the number that brings you before the court and me prosecuting you. When it might have been 4 different members of An Garda Síochána taking complaints from 4 different people, complaining about an activity which they must consider as perfectly lawful, otherwise they would have to arrest me. So they're now conspiring with members of the public to bring me before a civil court, operating the capacity of a lawful representative of what is sort of a conspiratorial mob in a civil jurisdiction where they have none themselves. Why is none of this being discussed? But they've only alluded to a risk and things like of that nature, of such nature. Only vagueness and wishy-washiness, but still have had to solidify their stance on one issue, and that was lower standards of evidence, which says that there are standards of evidence that don't satisfy due process of law, therefore they're not recognised standards of evidence. They're not recognised by the Constitution. So if something which is of a legislative nature or a section of some kind of amendment or addition to an act manifests itself and doesn't satisfy due process of law, it is by default automatically unconstitutional. Why does a court require another case for this? Why is this an inappropriate case if at the very outset in the schedule it was decided in the very first position, number 1, that the whole reason they're getting together is to test the constitutionality of said sections 115 and 117? Why did they abandon that for a more appropriate case midway through and not communicate that to the respondent? Why didn't they communicate that to me? Why didn't they communicate it to the public? This is a matter of public interest. Why wasn't it in the newspapers? What kind of a court system is this? What kind of hideaway is this? You can't be that vague and run away from the public when it's a matter of such public import. As the civil standard applies to a civil order made, The behavior, you see, this is the thing. We're trying to like blur the lines between civil and criminal. Say, well, we'll bring you through the civil court and we'll ask you to do something unreasonable that requires lesser standards than due process of law because we couldn't arrest you. But we've had to conspire behind your back, show bias, forego presumption of innocence and due process in order to bring you before a civil court where we have no jurisdiction to act again with partiality for a sort of partiality towards a sort of conspiratorial mob against you, the one who is now vindicated as just engaging in their rights. So they're exposed. And I mean, the legislations, they're exposed, and the people who would even stand beside them and say, no, we're doing right by you. We're doing right by the members of the public by engaging in this. They should know better than that. A guard should know he has no jurisdiction in a civil matter. They should know that prima facie evidence in and of itself is unsatisfactory, that it doesn't satisfy due process of law. And so how can it ever lead to a criminalisation if it doesn't satisfy what is required by criminal process? So a sort of a backdoor through the civil court to attempt to criminalise somebody, it can't be permitted to continue. It has to be removed. It simply couldn't be permitted to be a component of reasonable processes. It's totally unreasonable. Do you see? And they've shown how it's unreasonable. They've shown how these sections don't actually satisfy due process of law. It's the whole basis of the conclusion. Risk of unwarranted interference with personal rights. I'm sorry, there's no risk of it. You've already said that the convictions against me are quashed. It's not a risk of it. It's already occurred, and you've said that it has occurred on the basis of 137. For these reasons, I am satisfied that the orders made under Section 115 and 117 of the 2006 Act are ultra vires and should be quashed. As I've said, you're free to go, but there's only a risk of unwarranted interference with personal rights. So a month in prison is not unwarranted interference, but it results in a judge of the High Court quashing those convictions. How can it result in the quashing of convictions and remain only a risk of unwarranted interference? Are they saying that it's not blatantly obvious that somebody being put into prison for engaging in their rights, constitutional rights, is not unwarranted interference? How can that only be the risk of unwarranted interference? A month in prison, 2-year ban from engaging in your freedoms of speech is only the risk of an unwarranted interference? How can anybody sane of mind conclude that? That it isn't unwarranted interference to put a person in prison, drag them through the courts on a number of occasions, require large amounts of money from them for surety, and prevent them from preaching in the entire county they live in, as actually further impositions that resulted of an appeal made to the circuit court on the say-so of the opposition rather than the judge in charge. The judge basically gave carte blanche to the opposition to make up the conditions of the bail and the appeal. That's not normal court proceedings. The opposition was saying, well, we can have the appeal today if you want, twisting my arm. That's the sort of corruption going on. The judge was female judge, just sort of hand gestures and what? You're now giving your court over to the opposition to run it? But I was invited into the court, being told the appeal has been granted, the adjournment has been granted. Oh, the adjournment has been granted. Now let's go in and allow the opposition to make to tell you what the conditions of the appeal are going to be. What kind of a corrupt state is this? And then they would say that it's only the risk of unwarranted interference. These courts are corrupt. I mean, rotten to the core. And they want to say that this isn't an appropriate case to address those issues. How would you get a more appropriate case than a man being imprisoned on the basis of them? That's not a sane thing to say. That's highly unusual. That's not reasonable. Because sanity requires reasonableness. It's soundness of mind and the ability to remain logically consistent in what you're saying. This is logically inconsistent. Any normal measure of what is logic. To say that it is only the risk of unwarranted interference when a person has gone to jail, been told they can't engage in their freedoms of speech, been denied access to their child, all on the basis of the controversy around, for a short period of time, denied access to the child, all on the basis of controversy that resulted of this stuff in the local newspapers and throughout the community. And this is only the risk of unwarranted interference? By what measure? So I'll remain calm. The risk of unwarranted interference with personal rights associated with the broad definition of antisocial behaviour. Guys, a definition still hasn't been given for what is considered antisocial behaviour by the judge of the court that found that my behaviour was antisocial, but actually didn't give any specific reason as to why that was the case, completely failing everybody in the court. So, is it now that you can expect it's only a risk of unwarranted interference to spend a month in prison when you're perfectly innocent? Is it only the risk of an unwarranted interference to be prevented for over 2 years from engaging in what is your normal freedoms under threat of arrest and further imprisonment? Is this only the risk of unwarranted interference when now I've been told these are quashed and you're free to go? What kind of behaviour is that? In this case, is compounded by the lower standards of evidence, so lower than what is acceptable by due process of law, and proof. No proof was given, actually. Required under the legislation to criminalise behaviour which is the subject of a civil order. As the civil standard applies to a civil order, I can appreciate that. It shouldn't be the case where, but nobody's saying that what I was doing is criminal. So that doesn't actually rightly describe the situation. Nobody's saying that what I was doing was criminal. That has never been said. If it was criminal, it wouldn't have been in the civil court. What they're saying was it was a criminal offence not to obey with what I was told not to do. Even though what I was told not to do in and of itself by its own nature is not a criminal offence. It's not criminal to speak or record in public. But that's all the order says. You must not speak and record. Why? That's like saying you must not walk down the street. Why? See, the why was never given. Prima facie evidence was given, but the why wasn't. Prima facie evidence was given, but no proof was that I had done anything antisocial. So whether the definition of antisocial behaviour has been given or clearly defined or not yet. The court hasn't said why my behaviour was antisocial. So it hasn't given either a clear definition of antisocial behaviour or a reason as to why he thought or viewed I was behaving antisocial. That still hasn't been given to this date. 2-3 years down the line. I can't remember when the first case took place. It's a few years now. And they're saying it's only the risk of unwarranted interference. By what measure? That's not logical. That's not normal to say. Which occurred in this case is compounded by the lower standards under the legislation of criminalised behaviour which is subject of a civil order. You can't criminalise behaviour that's subject of a civil order. Nobody's inferring you can. It's criminalising the person who has failed to comply with something that's otherwise perfectly fair in society. So in effect, criminalising the person for engaging in their rights. That's what's happening. It doesn't actually criminalise the behaviour. You can't criminalise speaking and recording. They're trying to criminalise the person. As the civil standard applies to a civil order made, the behaviour in question, even if capable of amounting to a criminal offence, will therefore not have to be proved to a standard of beyond all reasonable doubt, which is the due process of law, it's the lawful standard. And will therefore not have to be. No, it won't. What does it mean? As the civil standard applies to a civil order made, the behaviour in question, even if capable of amounting to a criminal offence, will therefore not have to be proved to a standard of beyond all reasonable doubt, and the defendant can be placed under a civil order even if there is reasonable doubt as to the behaviour in question, and thereafter convicted of an offence by reason of the failure to comply with the civil order. Guys, do you realise how criminal that is? Do you realise that? How criminal that is? See that? Even if capable of amounting to a criminal offence. What should be said there is, as the civil standard applies to a civil order made, the behaviour in question, even if perfectly rightful activity, will therefore not have to be proved to a standard of beyond all reasonable doubt, and a defendant can be placed under a civil order, even if there is reasonable doubt as to the behaviour in question, or the accusation in question, and therefore convinced of an offence by reason of the failure to comply with the civil order. I mean, to suggest that that might actually be the case or afforded by some legislation that completely disagrees with the Constitution of Ireland is high treason. Whoever brought that legislation or made that amendment committed a betrayal of the state at a rudimentary level by trying to mesh civil and criminal and blur the lines between the two and afford a sort of a mob-like ochlocratic access to criminalise somebody eventually who's perfectly free to do what they've been doing. That's what's happening. It's affording the mob a voice in a civil jurisdiction, which allows them therefore to impact that person in a criminal aptitude if it were to ever to be allowed. And that can't be allowed, guys. I'm telling you now it can't. Because nobody could ever reasonably say that that's logical. Oh, you're perfectly right to do that, but if we get a mob to come in and say, you're not, then we'll stop you doing it, and it'll be on the basis that a guard who shouldn't really have any jurisdiction in here came in and could have stood up for the mob and said, this person should be criminalised if they don't do what we've told them not to do. If they don't cease doing what we've told them they're not to do, even though it's their right to do it, because they don't like what he said. They don't agree with him. What kind of a nonsense is that, guys? How is there a more appropriate case than this one to address that? They've already effectively addressed the constitutionality of those sections, unavoidably, but they're claiming they didn't. And they're inferring and implying that there would be a more appropriate case, even though it was number one on the schedule to check the constitutionality of those sections. Because you would first have to check the constitutionality of those sections to fully judicially review. Therefore, a judicial review didn't take place given the full implications and impact of the surrounding variables, when you take the constitutionality of the sections into account. But they're saying we didn't take them into account. Okay, so you judicially reviewed without taking the constitutionality of the sections into account, and you still found that I was free to go, which means that you did check the constitutionality of those sections. By way of quashing the convictions. See how simple that is? Will therefore not have to be proved to a standard of beyond all reasonable doubt, and a defendant can be placed under a civil order even if there is reasonable doubt as to the behaviour in question. Yeah, read that. The nexus, the connection between the original application for a civil order and its criminal counterpart under Section 117 is a cause for real caution. Why are they only talking about causes for caution and risk of unwarranted interference? And why nothing solid? Why nothing definite? This is a conclusion. They're supposed to have concluded things, not thrown them up in the air to hover. They're supposed to conclude things with finality because they've come to a final decision. So they must have arrived at a final decision having some form of finality on something. But all the conclusion seems to have done, really in effect, is thrown things up in the air for a more appropriate case in the future. Well, guys, by saying that judicial review is satisfactorily proving that the conviction should be quashed, is also, by extension, proof that the sections under which such convictions were made are unconstitutional. You can't say the judge operated wrongly in isolation from the sections. He operated wrongly, taking everything into account. Or he didn't operate wrongly. You understand what I'm saying? Like, you can't separate your decision from what went on in the court. You must take it into account. Moving on. Criminal offence. In breach of civil order but does not otherwise constitute criminal wrongdoing, a conviction may also be obtained. Yeah, I mean, they're basically saying that the sections are unconstitutional without committing to it in writing. Look, it says here, the nexus between the original application for civil order and its criminal counterpart under Section 117 is a cause for real caution for the part of the judge who is required to give effect to the provision as the initial civil procedure defines the outer limits of the behaviour which can constitute a criminal offence in circumstances where, either in respect of behaviour which actually amounts to a crime, a conviction may be obtained without proving the crime. No, guys, look, if it amounted to a crime, it would be in the criminal court. It's really very simple. If it amounted to a crime, I would have been brought before the criminal court, not the civil court. This is basic. Why is the High Court of Ireland not exhibiting a knowledge of basic law? This is a judge of the High Court of Ireland. It's just unacceptable. Look, is a case for real caution for the part of the judge who is required to give effect to the provision as the initial civil procedure defines the outer limits of the behaviour which can constitute a criminal offence. So basically, they're saying that civil starts where criminal ends, and vice versa. They're declaring to you that the civil court has nothing to do with the criminal court. That there's actually a border between them, and that's why they operate in different jurisdictions. So what's the guard doing in there? He should be out upholding the law. Should he not? Listen, behaviour which can constitute a criminal offence in circumstances where either I, in respect of behaviour which actually amounts to a crime, a conviction may be obtained without proving the crime, and in respect of behaviour which is in breach of a civil order but does not otherwise constitute criminal wrongdoing, a conviction may also be obtained. Guys, this is not an accurate assessment. Listen, if why if you're in a civil jurisdiction, you haven't committed a crime. And if you have committed a crime and you're being heard before a civil court, you need to be taken out of there and brought before a court of law. And the guards are remiss in not having arrested you. So because the guards didn't arrest me, and all the way along said, we've no reason to arrest you, have it on camera. We've no reason to arrest you, you're not doing it wrong, but it's just people are complaining and they're going to write this and what kind of a nonsense is that? By the way, there's a number of people here upset with what you're saying, and we're just going to... We'll see you there, right, on that day. Guys, if I had committed a criminal offence, I would have, listen now, let this land, the guard would have had to arrest me. A guard seeing a crime and walking away is a guard committing a crime. He's failing to occupy his office. If a guard is a guard, and Garda Síochána, the police, Metropolitan Police, whoever it is, if they see a crime taking place and walk away, they've committed a crime. I wasn't arrested. The only thing I was arrested for was not complying with "you must not speak and record." But I had reasonable excuse not to comply with that. I'm an Irishman with rights to speak and record. What crime did I commit? None. At what stage did I commit a crime? You didn't. You were before the civil court. Exactly. So why am I in jail? You can't be in jail. You're not in jail. Exactly. So why don't the courts recognise that there's a difference clearly defined between the civil court and the court of law? Criminal law, civil law, criminal law. The court of criminal law. There's a clear distinction. It's just been outlined. That where the criminal law begins, the civil where the criminal law ends, the civil law begins. There's a barrier between the two. So if you can't arrest me, guard, you can't criminalise me. It's really that simple. It like a judge of the High Court shouldn't be thinking that something can amount to a criminal offence if it's before the civil court. I mean, this is a judge of the High Court. Why is a judge of the High Court thinking that something can be a criminal offence before a civil court? Guys, really? The judge would have to call into question. This is unacceptable because you can't criminalise somebody through a civil process. You have to bring them through a criminal process to criminalise them. You can't criminalise somebody for failing to obey a civil order. when the basis of the civil order is not a criminal offence. You're not preventing them from doing a crime. So how can not doing a crime result in a crime? You didn't commit a crime, so that's criminal. Now, whatever you do, Mr. Tallon, don't go out and commit a crime. What am I not to do? Commit a crime. Okay. So then I don't go out and commit a crime and they criminalize me. You've committed a crime for not committing a crime. Okay? What? I've committed a crime for speaking, which isn't a crime. Yes, exactly. I've committed a crime for singing a hymn to Jesus Christ the Righteous in a public place in Ireland, when the Constitution acknowledges my obligation to do so, to humbly acknowledge all my obligations to my divine Lord Jesus Christ in the preamble of the Irish Constitution. Yes, Mr. Allen, because the civil court told you not to. But no, it's not the singing and recording that's the problem. It's the fact that you didn't stop doing it when we told you to. What? Are you being serious? Look, you're not doing anything wrong. Scribble, scribble, scribble. Please stop doing not something wrong. Because Anne doesn't want you to do not something wrong. And John as well. And Frank. Mary. Philippa. Okay, now we have 7 people. 7 people we can get before the court. And the civil court. And a very highly ranking member of An Garda Síochána will be there. Oh, he'll be there in the civil court. What's he doing there? Representing these other 7 people against you. Why? What did I do to them? They don't like what you're saying. What I'm saying? Yes, what you're saying. Okay. These people don't like what I'm saying, so they're going to drag me into a civil court. A guard is going to bring me there, even though he has no right to be there. He's going to represent a conspiratorial mob. The only thing they lack is pitchforks. Oh. And then they're going to have an issue about whether something constitutes a crime in a civil jurisdiction or not. When they couldn't arrest me and bring me before a criminal court for the same thing. We can't arrest you for this, but the judge of the High Court is it criminal offence, or is it, even if it constitutes a criminal offence in a civil court, I would say we need to find an appropriate judge of the High Court based on what we've read. That's what I would say. Because what I see here is corruption. At least severe incompetency on the basics of law. Basic, very, very, very rudimentary understanding of law. We couldn't arrest you for this, but even if it's capable of amounting to a criminal offence, even if something is capable of amounting to a criminal offence in a civil jurisdiction, what's the point? Would you not ask yourself, what is the point in engaging the High Court of Ireland when they don't know that something brought before the civil court cannot amount to a criminal offence, but they're questioning whether it's an unwarranted risk that somebody might have their rights infringed upon as a result of having been criminalised by a civil court. But even if it's capable of amounting to a criminal offence, the judge says, I have decided that the standards of fairness inherent in the concepts of constitutional justice and equality before the law which inhere in our constitutional order are not met where civil order is drawn under section 115 in a manner which extends beyond the mischief of antisocial behaviour covered in the evidence led before the district court, and in a manner which encroaches into areas of human activity which are perfectly lawful and are constitutionally protected even. Wow. So she's acknowledged all of that, but not that section 115 is unconstitutional. I have decided that the standards of fairness inherent in the concepts of constitutional justice and equality before the law which inhere our constitutional order are not met where civil order is drawn under section 115 in a manner which extends beyond the mischief of antisocial behaviour. How can you say, after making a statement like that you haven't tested the constitutionality of section 115? Which extends beyond the mischief of antisocial behaviour. Mischief. Covered in the evidence led before the district court and in a manner which encroaches into areas of human activity which are perfectly lawful and are constitutionally protected. By failing to tailor the civil order made to capture recurrence of behaviour adjudged on the evidence led to be antisocial. By failing to tailor the civil order made to capture recurrence of behaviour adjudged on the evidence led to be antisocial. The district judge exceeded the jurisdiction vested under Part 11 of the 2006 Act. Is it just me not understanding what that means? No. What way is this formulated? I have decided that the standards of fairness inherent in the concepts of constitutional justice and equality before the law which inhere in our constitutional order are not met where civil order is drawn under section 115 in a manner which extends beyond the mischief of antisocial behaviour covered in the evidence led before the district court and in a manner which encroaches into area of human activity which are perfectly lawful and are constitutionally protected. Guys, that's a fudge. It's a fudge. This is coming out of the High Court of Ireland. By failing to tailor the civil order made to capture recurrence of behaviour adjudged on the evidence led to be antisocial. So let me put some clarity into this. Risk of unwarranted interference. Then a judgment made that there was unwarranted interference. Facilitated by 115. Section 115. Yet they claim they haven't dealt with section 115 and they're waiting for a more appropriate case. By failing to tailor the civil order made to capture recurrence of behaviour adjudged on the evidence led to be antisocial behaviour. There's a lack of commas. By failing to tailor the civil order made to capture recurrence of behaviour. Civil order made to capture recurrence of behaviour adjudged on the evidence led to be antisocial. Believed to be antisocial. The district judge exceeded the jurisdiction vested under Part. I don't think that sentence makes sense. I think it's indecipherable use of language. By failing to tailor the civil order, which was made to capture recurrence of behaviour adjudged on the basis of evidence which was led to be believed as antisocial. So, antisocial hasn't been clearly defined. It hasn't been proven how the evidence led to that. Priorly, the judge said that the evidence was lower than what is acceptable, a lower standard. Uh, so the evidence is lower than what is acceptable. The antisocial is definition is too broad. It doesn't. So how then can the judge arrive at we didn't test the constitutionality of the section? Or that question remains open? How is that an open-ended question when that judgment has been made? Even though that language is fudge, enough has been said to show it's just unclear. It's unclear what's being said. It needs to be cleaned up. Basic grammar shouldn't be a problem with a High Court judge. It shouldn't. I'm not educated to a high standard and I can compose a sentence that's decipherable to the reader. I'm not mocking the High Court judge. I'm saying that there should be standards. Where are these standards, guys? Do you ever feel like the last man standing? Okay, focus. It's gone so bad. Similarly, the failure to tailor the order to the offending behaviour results. Oh, hold on. Offending behaviour? Is that not an assumption that goes against the final ruling? But okay, for the purposes of the isolation of the mechanisms. Similarly, the failure to tailor the order to the offending behaviour results in a disproportionate interference with the applicant's personal. Should there be a proportionate interference on somebody who's innocent? What's a proportionate interference? So, on the one hand, it's saying there's only a risk of unwarranted interference, and then it's saying it results in a disproportionate interference. Which is it? The risk of unwarranted interference or disproportionate interference? How can something over the course of maybe 300 words be so disconnected and inconsistent? How can it be so fudged, yet still point to the sections being unconstitutional and result in a quashing of the conviction, whilst claiming that the testing of the constitutionality of the sections wasn't achieved and is still open and would need a proper case, an appropriate case? That's like a whole lot of ping pong balls in a small room. That is all over the place. Isn't it? But still effectively addresses that my rights were not respected and that it wasn't proven that I committed a crime at any stage. There's only the risk of an unwarranted interference, and then it's clearly stated that there's a disproportionate interference. It's saying that there must be clearly defined barrier between criminal and civil. but it didn't come into question why the guard was in the civil court, acting in a biased way, foregoing presumption of innocence and showing partiality, foregoing presumption of innocence, and acting out of his jurisdiction as previously stated. Excuse me. Why? Why then say it remains an open question to be determined in an appropriate case as to, it hasn't said why this is an inappropriate case. As to whether together section 115 and 117 operating in a manner which results in a conviction on foot of behaviour which either is or is not in itself criminal wrongdoing on a civil standard results in a conviction obtained otherwise than in accordance with the due process of law. So they're saying, despite that we have quashed your convictions, Mr. Tallon, it still remains a question whether, oh, by the way, because we've quashed your conviction, because we found that there are lower standards of evidence than is required by due process of law, but still conviction obtained otherwise than in accordance with due process of law. Whether it results in that or not, we're still not sure, and we need another case for that. But you've already stated that there are lower standards of evidence, which says that there are lower standards of evidence required to satisfy due process of law. But then you're saying it's still a question whether it results in a conviction obtained otherwise than in accordance with the due process of law. How does that remain a question in anybody's mind after you've quashed the convictions? Because the standards were lower than what is normally accepted. Lower implies that. Lower than due process of law. What is due process of law? You've already stated that that's the case, and now you're stating that it hasn't been obtained, that we don't know that yet. We don't know what we already stated. Does anybody see that this could not be anything but demonic? Why do I say that? Because they come from chaos. That's what I mean by ping pong balls in a small room. They're all over the place. What has been effectively stated, and what is true to law, is that standards of evidence resulting in a conviction cannot be merely prima facie, or just spoken words of somebody claiming to be a witness. Otherwise, Joe and Mary over there could go into the court and say Philip stole their sheep when he didn't. And Philip would go to jail for stealing the sheep. They have to have some proof. So evidence is not always equating to proof. Did you know that? Now you do. Prima facie evidence is just the person speaking to the judge about what they saw. The judge can't confirm whether they're telling the truth or not, based on what they've said alone. But if what they've said backs up what they prove, they present the solid irrefutable proof, which is another form of evidence. Evidence is just what's submitted to the court, which is another form of evidence, solid irrefutable proof. Then the judge could reasonably come to a conclusion and convict a person on the basis of it. But what you must know coming into this case is that it is insufficient before the court of law. It doesn't satisfy due process to convict somebody of anything on merely prima facie evidence or evidence at face value, according to the law, because people can lie. What is there a complete absence of? Solid, irrefutable evidence that has been shown to be in and of itself criminal. No solid, irrefutable evidence has been presented before the court. That's not a lower standard of evidence. It's insufficient evidence to lead to any manner of conviction. It simply, in and of itself, does not satisfy due process of law to make any conclusive decision on the basis of prima facie evidence alone. The High Court judge should know this. It shouldn't be a question in her mind. This should be basic. Absolutely. She should have that straight off. Oh no, prima facie alone, insufficient. Why? Doesn't satisfy due process of law. She's entertaining it. The High Court of Ireland are entertaining the idea. There are lower standards of evidence. It's questionable, risk of unwarranted, but you're free to go. And we would need to look at this in an appropriate case. This is coming from the High Court of Ireland. These people are supposed to be educated on the law to the highest standard. Some of the highest educated people on the law in the land are supposed to be in the High Court. And that's what they come up with. That's like somebody's sloppy homework. Who's only learning how to speak English and basic grammar. That's what that's like. It is. That's like somebody who's just learning. And I'm telling you, I'm not mocking. We're supposed to upkeep a standard here in Ireland. At least hold things to the law in the High Court. We're going to need an appropriate case to do that, lads. How is there a more appropriate case? The whole reason it was called the court was called together for this was to test the constitutionality of it and judicial review. They abandoned the constitutional testing of the constitutionality of the sections, favour the judicial review, in isolation of that, and find that the judge's behaviour under those sections didn't satisfy due process of law. Well, that says that the sections are unconstitutional by extension. And it's actually stated in a number of places that they're unconstitutional. But then they set a new parameter, which wasn't the initial one, and they said whether together 115 and 117 operating in a manner which that wasn't the brief. The brief was to test this constitutionality of the sections. You test them in isolation from one another first. And if either one of the two doesn't satisfy due process of law, then together they don't. Because you can't say section 115 doesn't satisfy due process of law, but together with section 117 it does. Do you see how they're appealing to the obscure here? Absolute obscurity appealing to further obscurity. Dig a field over there. Dig out into that field. This is ridiculous. It's not even done with proper grammar, as far as I know. You're free to go. We're satisfied that the judge didn't behave properly under those sections. But those sections, we haven't dealt with them yet. Waiting for an appropriate case. And then they set a new framework for that case that was nothing to do with this case, in the sense that it wasn't the exact wording. And I'll go back to that wording so that you know, because it's fresh in your mind. The case concerns the constitutional interpretation and application of the Antisocial Behaviour Order provisions of the Criminal Justice Order Act 2006 and the constitutional soundness of certain of those provisions. Okay? That's all it says. That's what they were to test. Now they're setting a new criteria for an appropriate case that'll be set up sometime that'll be disconnected from this one. How about that? What would be the point of doing that exactly? How would you have any context then? That's not normal behavior. How do you establish case law in the absence of a case or a claimant or a respondent or any of that? How do you do that? You can't. Of course you can't. Is that what they're avoiding, do you think? Is that what they're trying to avoid? Well, they're exposed. And I'm not going to drop it. They are exposed. And they need to deal with it properly. Because what they're doing is criminal, and now it's at the highest levels of the courts, the High Court of Ireland. They want to correct this quick style, because kicking this down the road and stalling it isn't going to work. Because they have to hold things to the powers instituted by God Most High. They're not going to hinge further corruption off of this and expect me to just lay low and be so satisfied that I'm not going to end up in prison now because they quashed convictions that weren't actually lawful in the first place. And there's only the risk of interfering with you there, right? Which says what? Well, we haven't certainly interfered with you there, have we? By what measure? In Jesus' name, let Satan be removed from there, according to his will and purpose. Jesus' will and purpose. Praise the Lord. The Lord is